Namaste. सदा खुश रहो बिटिया. I, Jv'n Dr L Sharma, Professor, jyoti Vidyapeeth, Women's University, Jaipur. Today our topic is Supreme Court of India. The Indian Constitution under Article 124(1) states that there shall be a Supreme Court of India consisting of Chief Justice of India and 31 judges including the CJI. Appointment of CJI and other judges. Every judge of the Supreme Court is appointed by the President of India after consultation with such judges of the Supreme Court and the High Courts of states as the President may deem necessary for the purpose. However, in the matter of appointment of the judge other than Chief Justice, consultation of the Chief Justice of India by the President is obligatory. Qualification. To be a judge of Supreme Court, one must be a citizen of India, has been a judge of High Court at least for 5 years, has been an advocate of High Court for at least 10 years. It is a distinct jurist in the opinion of the President. Tenure. A judge of the Supreme Court retires at the age of 65 years. He may also resign from his office. Removal. A judge of Supreme Court can be removed by the President from his position only on the ground of proved misbehavior or incapacity if a resolution in this regard is passed by the Parliament supported by the 2/3 of the members present and voting in each house and the majority of total membership of each house. Jurisdiction of the Supreme Court. The Supreme Court has 3 types of jurisdiction. First one original, second one appellate, and third one advisory jurisdiction. Beside this, there are certain jurisdiction also. Original jurisdiction. In original jurisdiction, Supreme Court has a lot of powers. First one, it's exclusively original jurisdiction extended to any dispute between Government of India and one or more state, or between Government of India and any state or states on one side and one or more state on other side, or between 2 or more states, if and insofar as the dispute involves any question whether of law or of fact on which the existence or the extent of legal rights depends. Second, in addition, Article 32 of the Constitution gives an extensive original jurisdiction to the Supreme Court in regard to enforcement of the fundamental rights. Third one, it is empowered to issue the direction, orders or writs, including the writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari to enforce them. Fourth one, the Supreme Court has been conferred with the power to direct transfer of any civil or criminal case from one state high court to another state high court, or from one subordinate court to another state high court. The Supreme Court, if satisfied that the cases involving the same or subsequently the same questions of law are pending before it and one or more high courts, or before 2 or more high courts, and that such questions are sustainable questions of general importance, may withdraw a case or cases pending before the High Court or the High Courts and dispose of all such cases. Under the Arbitration and Conciliation Act 1996, international commercial arbitration can also be initiated by the Supreme Court. The appellate jurisdiction of the Supreme Court can be evoked by a certificate granted by the High Court concerned under Article 131 1, 133 1 or 134 of Constitution in respect of any judgment, decree or final order of High Court in both civil and criminal cases. The Parliament is authorized to confirm the Supreme Court any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceedings of a High Courts. Appellate jurisdiction. The Supreme Court has a very wide appellate jurisdiction, oral courts and tribunals in India, as much as it may in its discretion grant special leave to appeal under Article 136 of the Constitution from any judgment, decree, determination, sentence or order in any case or matter passed or made by the court or the tribunal in the territory. Advisory jurisdiction. The Supreme Court has advisory jurisdiction in a matter which may be referred to it by President of India under Article 143 of the Constitution of India. There are provisions for reference or appeal to this court under Article 3171 of the Constitution, Section 257 of Income Tax 1961, Section 7 bracket under bracket 2 of Monopolies and Restrictive Trade Practices Act 1969, Section 130A of the Custom Act 1962, Section 35H of Central Excise and Salt Act 1944, and the Section 82C of the Gold Control Act 1968. Appeals also lies to the Supreme Court under the Representation of the People Act 1951, Monopolies and Restrictive Trade Practices Act 1969, Advocates Act 1961, Contempt of Court Act 1971, Customs Act 1962, Central Excise and Salt Act 1944, Enlargement of Criminal Appellate Jurisdiction Act 1970, Trial of Offences Relating to Transaction in Securities Act 1992, Terrorist and Disruptive Activities Prevention Act 1987, and Consumer Protection Act 1986. Election petitions under Part 3 of the Presidential and Vice Presidential Election Act 1952 are also filed directly in the Supreme Court. Under Article 129 and 142 of the Constitution of the Supreme Court has been vested with the power to punish for the contempt of court, including the power to punish for contempt of itself. Public interest litigation. Although the proceedings in the Supreme Court arise out of the judgment or order made by the subordinate courts, including the high courts, but of the late of the Supreme Court has started entertaining matters in which interest of the public at large is involved, and the court can be removed by any individual or a group of persons either by filing a writ petition at filing counter of the court or by addressing a letter to the Honorable Chief Justice of India highlighting the question of public importance for evoking this jurisdiction. Such concept is popularly known as public interest litigation, and the several matter of public importance has become a landmark cases. Provisions of legal aid. If a person belongs to a poor section of the society having annual income less than 18,000 rupees, or belongs to the scheduled caste or scheduled tribes, a victim of natural calamity, is a woman or a child or a mentally ill or otherwise disabled person or an industrial workman, or is in custody including custody in protective home, he or she is entitled to get a free legal aid from the Supreme Court Legal Aid Committee. Amicus curiae. If a petition is received from the jail in or any other criminal matter, if accused is unrepresented, then an advocate is appointed as amicus curiae by the court to defend and argue the case of the accused. In civil matter also, court can appoint an advocate as an amicus curiae if it thinks it necessary. In case of unrepresented party, the court can appoint amicus curiae in any matter of general public importance or in which the interest of the public at large is involved. High courts. The high courts stands at the head of the state judicial administration. There are 24 high courts in the country having jurisdiction over more than one state. Among the union territories, Delhi alone has a high court of its own. Other 6 union territories come under the jurisdiction of the different state high courts. Each state high court comprises of chief justice and other judges as the president may from time to time appointed. Each high court has a power of superintendence overall courts within its jurisdiction. Advocate General. There is an Advocate General for each state appointed by the governor who holds office during the pleasure of the governor. He must be a person qualified to be appointed as a judge of the High Court. His duty is to give advice to the state government upon such legal matters and to perform such other duties of legal character as may be referred or assigned to him by the governor. The Advocate General has a right to speak and take part in the proceeding of the state legislature without the right to vote. Lok Adalats. Lok Adalats, which are voluntary agency monitored by the state legal aid and advice boards, they have proved to be successful alternative forum for resolving of dispute throughout the conciliatory methods. Dear students, this is all about the Supreme Court of India. If you have any problem, then mention your problem in a comment box. Thank you.